Welcome everyone. This is class number 9 of the IBIS Prep MBE crash course. And today we're going to do our workshop on constitutional law. And without further ado, we're just going to jump right into it. My dog is not happy we're doing common law. Sorry if you hear squealing in the background. Let's 25 questions. And I actually might even start off having a student read the first one because I need to make sure my dog is under control. Does anyone want to volunteer to at least just be the reader for the first one and the answers?
I can do it.
Thank you so much. All right, spin the wheel. Here we go.
Great. To preserve the appearance and accessibility of its Capitol building, a state enacted a law prohibiting the display of any sign on any portion of the public sidewalk surrounding the building. A group of 5 demonstrators who wanted to protest inadequate state funding for children's services applied for a permit to march single file on the sidewalk surrounding the Capitol building. Each demonstrator planned to carry a 2-foot square sign that would read, "Our lawmakers do not care about our children." The group's permit application was denied pursuant to the state law, and the group has filed an action challenging the law's constitutionality. Should the court uphold the law's constitutionality? A, no, because even though the sidewalk at issue is not a public forum, the prohibition against the display of signs is more restrictive than needed to serve a legitimate government interest. B, no, because the sidewalk at issue is a public forum and the prohibition against the display of signs is not narrowly tailored to serve a substantial government interest. C, yes, because even though the sidewalk at issue is a public forum, the prohibition against the display of signs is necessary to serve a compelling public interest. D, yes, because the sidewalk at issue is not a public forum and the prohibition against the display of signs is reasonable.
Okay, thank you. Just the reader now. So everyone take about 30 seconds and then we'll wait for answers. Okay, do we have any thoughts in the chat box? Just one answer, 2 answers, a few B's? We have a lot of B's. So B is one of the ones that says the sidewalk is a public forum. Do we agree that a sidewalk is a public forum? Yes. What's another example of a very common public forum?
A bus, like advertising on a bus.
Bus, public park. I was going for park, but there's plenty of good answers. Yeah, I think sidewalks and parks are like the stereotypes of public forums. And then what do we have between C and D? Yes, because even though it's a public forum, it's necessary to serve a compelling public interest. And here we're saying it's not narrowly tailored. So can anyone explain the difference between B and C and why they chose B?
Okay, B is strict scrutiny and C is intermediate, I think.
It's the opposite.
Isn't it opposite?
It's the opposite, yeah.
Opposite.
Yeah, if
because
it's compelling.
substantial.
Okay, can someone explain their thought about it being the opposite?
Well, I just like under strict scrutiny, it needs to be necessary and compelling. I just use this isn't probably not going to help anyone, but my initials are NC. So when I see necessary, I would go compelling. And I just know those two have to be together for strict scrutiny.
Substantial is when it has to do with intermediate scrutiny.
Right.
This is, if I'm not mistaken, this was viewpoint.
Well,
Neutral.
in that case, B is wrong, right? Because
Yeah.
this is speech.
I thought it was C because is it content-based regulation?
It's not. It's the display of any sign. So
Oh,
it's
okay.
content neutral.
Okay.
I mean viewpoint neutral, yeah. So
we like B?
yeah.
All right, good job. And we got to go
Wait, I'm confused. Sorry, why is it B?
I know.
Why I got it good, but my thought process was wrong.
It's okay. Let's learn as a class. Okay. So B is correct. The ban on all signs on any part of the public sidewalk here is not narrowly tailored to serve the interests of preserving the appearance and accessibility of the Capitol building as is required for time, place, and manner regulations on speech in public forums. So we had to understand what it is here, and don't let anyone confuse anyone. We had the answer correct, right? This is a time, place, and manner restriction on a public forum. Why? Because it was a sidewalk, which is indeed a public forum. And why was it time, place, and manner? Because it wasn't content-based, it was content neutral, right? And we can see from the question itself, it says any sign, right? It's not saying a sign about this content. It's not content-based, right? If it was content-based, then it could have been this strict scrutiny. But because it's intermediate, heightened intermediate, you know, time, place, and manner, we would have this B answer. Does that make sense? If we go to, let's look at this answer.
Yeah, thank you, Natalie. I didn't even, sorry for her pointing it out because I didn't see all signs and I read really quick. So thank you for that.
The court should not uphold the constitutionality of the law because it's prohibiting speech in a public forum in a way that is not narrowly tailored to serve its substantial government interest, right? It's that time, place, and manner one. Sidewalks are considered to be a public forum where speech may be regulated as long as reasonable time, place, and manner. This means it must be content neutral, any sign narrowly tailored to serve an important government interest, like the answer said, and leave alternative communications, right? These three pieces create time, place, and manner. This piece was given to us by the question. This piece was given to us by the answer. Therefore, we had the perfect harmony of the answer. Here, however, the regulation fails this test because although preserving the appearance and accessibility of the Capitol building may be an important interest, the ban on all signs on any portions of the sidewalk is not narrowly tailored to serve that interest. Either way, we're just looking for the correct verbiage. Even if you didn't know the correct ruling on the case, B could only have been the correct answer. Even if it would have said yes, you know, that still would have had to have been the best answer because it has to apply the correct test. Anyone have any questions about this? We're good? All right. El próximo. Okay. Is the state law constitutional? Under state law, oil and gas rights can pass by will or through intestate succession. Some oil and gas rights in the state have been divided into very small interests after several generations of passing by intestate succession. It therefore is difficult to enter into extraction contracts in the state because of the need to include large numbers of heirs for any given tract of land. To remedy this problem, the state has enacted a law that provides that at death of an owner of less than 1% of the oil and gas interest in the tract of land, that owner's oils and gas rights are extinguished and his or her interests are transferred pro rata to the remaining owners. Is this law constitutional? No, because the law affects a taking of property without just compensation. No, because the law unduly burdens interstate commerce and oil and gas production. Yes, because property inheritance is a privilege created by state law. And yes, because the law rationally promotes the legitimate state interest in fostering resource development. Take a moment. We have any answers? A lot of A's. Everyone's going with A. Yeah, this seems to be a taking. Anyone disagree? Speak now. No, I think A is a proper answer. This is a taking. You're going to take 1% of oil and gas. I've been to Texas and I know that 1% of oil and gas interest could actually be a lot of money and that could equate to a lot of land. So they got to chill with this taking. Let's look at the explanation. A is correct. The law affects a taking of property because it extinguishes an owner's interest in the affected properties without just compensation. It does not matter that the owner's interest in the property is very small. And like I said, 1% in oil and gas in Texas might be bigger than we all think. Anyone have any questions about this one?
I just got thrown off because it said at death. So then I was like, well, how are they taking it away? But so it applies to that. There's two, correct?
And just a way of understanding property law, which next week we'll really get to understand, is your interests and your heirs' interests are one and the same. You know, that's how you inherit and devise property and descend property. So if they're taking it from your heirs, they might as well be taking it from you. I think that's a fair way of looking at it. Is that?
Yeah,
so,
thank you. Yeah.
Any other questions about this? And trust me, property next week is going to be zero fun. Let's skip this one. It looks kind of long. Also, I want to pull up our sheet and make sure that we're documenting these things appropriately. So I think it's a just give me a moment. So during our MBE course. I think it should be in the week 1 folder. Yeah. I almost didn't know if I could find that. All right, but I had a plan. I was just gonna do it on a different document. Am I freezing right now? No? Okay. All right, thank you. I just felt cold. So we did contracts, which by my estimation would have been 521. And now we're at 6.4. And we can surmise the following points. Can anyone tell me the scrutiny level for time, place, and manner?
Intermediate when
Intermediate.
it's content
Intermediate.
neutral.
And then what was the next one?
Takings clause,
Yeah, takings clause.
even
Uh,
if it's 1%.
Yeah, excellent. All right. Does anyone mind reading this question and answers to the class?
I'll do it.
Thank you.
Is the court likely to dismiss the action? A federal statute provides states with funds for child welfare programs, subject to the condition that such programs be administered in accordance with federal standards. The United States sued a state in federal court for injunctive relief, arguing that the state's child welfare programs, which were funded in part by federal funds dispersed under this statute, failed to comply with federal standards. The state has moved to dismiss the action. Is the court likely to dismiss the action? A, no, because Congress can place any condition on the receipt of federal funds. B, no, because the 11th Amendment does not bar actions brought by the United States. C, yes, because the 11th Amendment bars actions against a state in federal court. D, yes, because the protection of child welfare is reserved to the states.
So everyone just take 30 seconds and think it out. We have any answers? Okay. Some B's, some A's, some D's. All right. All right. Let's hear from the B's, from the representatives for the B's very quickly. Why do you think it's B? Iona, if you don't mind.
Hi, can you hear me?
Loud and clear.
I think it's B because I think if my thought process, A says can place any condition on the receipt of federal funds, and I just from doing prior questions, any is quite an absolute, and so I thought it was no, and I eliminated A for that reason, so that's why B I thought was the answer.
Solid argument. All right. Can I hear from any of the A delegation? Anyone still thinking they're gonna?
I was thinking about the funds with no strings attached, but that's the only argument I have.
The A delegation, that's not political, right? I'm allowed to say that. Did anyone, did Iona convince anyone? So Omar's saying conditions need to be related, but can't be unduly coercive. All right, anyone from the C delegation? I don't think anyone is from the C delegation. How about the D delegation?
I was the only one that picked D. I thought this was an infringement question. I thought it was like, I thought the federal statute was infringing upon the states' rights. And I just thought child welfare would be reserved for the states to do what they deem appropriate with it.
Okay, interesting. So someone else said states can't sue states and citizens can't sue states, but I'm not sure if the US can. I tend to agree that the US can sue a state, right? The federal government is not barred from suing the state.
So then it's B.
I think it's a true statement of law. Again, like I said, I'm not a machine, right? I think B is a true statement of law, and I agree with Iona that any condition is strong. That would lead me towards B. Does anyone want to save me from red?
I just have a question to walk through that answer choice. Like you said, it's a correct statement of law. It is, but is that why they're going to dismiss it? Because they can? Like, is that what we're saying when we pick B? Like, because they can sue, then they likely not dismiss it.
Okay, let's walk through the question. So, federal statute provides states with funds for child welfare programs subject to these conditions. The United States sued a state in federal court for injunctive relief, arguing that it sucks. Can they do that? Yes, they can do it. Therefore, should they dismiss the action? No, they shouldn't. B is the answer. It's kind of my way of arguing through it. Like, B is a correct statement of law, and B also applies to it. Is A correct? No, like, because I think Iona's right. Any condition on the receipt of federal funds, like, you don't get federal funds unless you like dress up like a pony and, you know, dance around. I don't know. That seems like a lot, but I could get this one wrong. That's what I'm saying. Does anyone still think it's A? After me and Iona have argued for B? The defense team of Andrew and Iona? The D delegation? Whew. All right, Iona, let's go. B is correct. The court will not dismiss the action because between the United States and a state, not because of private party or foreign government or state as barred by the 11th Amendment. A is incorrect. Congress may not impose any condition, excellent Iona, whatsoever on the receipt of federal funds. Conditions on receiving federal funds must satisfy certain requirements, including that they must be clear, in service of the general welfare, and relate to the federal program. C is incorrect. As stated above, the 11th Amendment bars only actions by private parties or foreign governments against state and federal court, not all actions against the state. D is incorrect. Child welfare protections do not exclusively belong to the states. So here I'm going to write two things. One is the federal government can sue the state. And then I'm also going to write D, because you know what? I don't think everyone was so confident in knowing that the child welfare protections do not exclusively belong to states. Let's just nail that down, right? Child welfare programs do not belong exclusively to the states, meaning Fed, Gov can regulate. Fair enough? Maybe I should zoom in for Scarlett. I don't know if she's here.
Can you just put extended explanation for a second?
Of course.
Thank you.
The 11th Amendment bars any federal suit against any one of the states by citizens of another state or by citizens of subjects of any foreign state. In other words, the 11th Amendment justifies the judicial power by prohibiting a federal court from hearing a private party's or foreign government's claims against a state government. The 11th Amendment essentially bars only suits for damages, however. It does not bar most suits for injunctions. Under the spending power, Congress has the power to spend. There's no independent congressional power to pursue the general welfare. The only relevance of the general welfare is that if Congress, when taxes and spends, must be pursuing the general welfare. The requirement has very little significance today. B is correct. The 10th Amendment modifies judicial power by prohibiting a federal court from hearing a private party or foreign government's claims against a state government, right? 11th Amendment is sovereign immunity. It protects the states from being sued by individuals or private parties, but it does not protect the federal government from suing the state. It also doesn't protect the states from suing the state. If a state sues a state, does anyone know who has exclusive jurisdiction?
The Supreme Court.
Yeah, Supreme.
Yeah, okay. Good. Learning is fun. My dog being annoying is not. All right, let's see if anyone want to volunteer to read this question? And anyone know a good dog trainer in Miami, Florida?
I can read it.
Thank you, Grace.
Okay, is the court likely to grant the reporter's motion to dismiss? A reporter writing an article about a politician offered the politician's estranged daughter $10,000 for information about the politician. The daughter agreed and provided the reporter with the information he sought. Subsequently, the daughter's information appeared in the newspaper article by the reporter, but the reporter refused to pay the daughter. Okay, sorry. The daughter sued the reporter in state court for breach of contract on the basis of generally applicable state contract law. The reporter has moved to dismiss the action solely on the ground that the daughter's lawsuit violates the freedom of the press clause of the First Amendment. Is the court likely to grant the reporter's motion to dismiss? A, no, because the daughter is not a state actor. B, no, because the First Amendment does not shield reporters from generally applicable state law claims. C, yes, because the state contract law as applied to the reporter inhibits freedom of the press without a compelling government interest. D, yes, because the politician is a public figure and any information about him is in the public domain.
Awesome job, Grace. Take 30 seconds, everyone, and let's see what we think. Anyone have any thoughts? Well, some people didn't listen. All right, we have some A's and some B's. Mostly B's. Only one A. Does the A want to defend A?
Yeah, I'll defend it. The First Amendment only applies when a state action is involved, and she's the daughter, she's the one suing. Or maybe. I still think it's A, I just can't explain it.
Okay, can anyone explain why they think B is in basketball?
Because this is just a breach of contract claim, not some sort of constitutional challenge. So state actor wouldn't even be applicable here. And she should still be able to sue under breach of contract.
From my opinion, the reporter here wants to take advantage, saying that it's information, public information, as if he didn't have to pay for that.
Anyone else defending B? Hannah, maybe? What do you think?
I just spoke why I said it was B.
I can't see everyone's screen. I'm so sorry.
You're good.
All right, let's go with B. You did a good job. Hannah, good job. I'm so sorry. I'm gonna change my adjustment so you're who I'm looking at now. Okay, let's look at B. B is correct. The Supreme Court has consistently rejected claims that the freedom of the press protected by the First Amendment exempts press activities from laws of general application such as contract law. Here, there's a valid enforceable contract between the reporter and the daughter. A is incorrect. It's irrelevant that the daughter was not a state actor. The requisite state action here is state contract law from which the reporter seeks an exemption. The Supreme Court has consistently rejected such claims for exemption. Are we okay with that? No, everyone's shaking their head yes or no? Right, this was a contract claim. So the First Amendment does not shield people from contract claims, from state contract claims, right? Good job, Hannah. Okay. Someone mind reading this one? That hasn't read yet?
I'll read it.
Thank you.
So here's which of the following arguments offered by these plaintiffs is likely to be the most persuasive in light of applicable precedent? The state statute. So small retailers located in a particular state are concerned about the loss of business to certain large retailers located nearby and bordering states. In an effort to deal with this concern, the legislature of the state enacted a statute requiring all manufacturers and wholesalers who sell goods to retailers in the state to do so at prices that are no higher than the lowest prices at which they sell them to retailers in any of the states that border that state. Well, I need to just one more time. In an effort to deal with this concern, the legislature of the state enacted a statute requiring all manufacturers and wholesalers who sell goods to retailers in the state to do so at prices that are no higher than the lowest prices at which they sell them to retailers in any of the states that border the state. Several manufacturers and wholesalers who are located in states bordering the state and who sell their goods to retailers in those states and in the state bring an action in federal court to challenge the constitutionality of the statute. Which of the following arguments offered by these plaintiffs is likely to be the most persuasive in light of applicable precedent? The state statute. Is it A, deprives them of their property or liberty without due process of law? Is it B, imposes an unreasonable burden on interstate commerce? Is it C, deprives them of privilege or immunity of national citizenship? Or is it D, denies them the equal protection of the laws?
Let's take a couple, reread this. We'll take like 30, maybe even 45 seconds in this one. This one's tough. I believe it's tough. All right, we have any answers? Overwhelming B delegation. Can someone explain why they think it's B?
Did process of elimination I knew it wasn't due process and had nothing to do with immunity. And I kind of felt like B was the correct answer to my gut.
Okay, anyone else?
Also, just because it's dealing with manufacturers and wholesalers, and then I don't know, it's kind of like topsy-turvy, but just because it's dealing with the fact of like the channels and instrumentalities of goods, that's kind of how I just took the question to be speaking upon commerce.
Okay, Issa, I like what you were saying. Can you explain that? Why it's B and not C?
Yeah, I feel like C is the privilege or immunity clause, so there's got to be discrimination against out-of-state residents, and I don't think that's what's going on here. So B is the only one that's kind of related to what it's talking about. It's kind of creating a burden to all these manufacturers.
Exactly, I love that. And if anyone's watching the recording, they're just going to see me popping up at different places. All right, let's go with B, imposing a reasonable burden on interstate commerce, not privileges and immunities, because like Issa was saying, it's not necessarily discriminating against people from a different state. It's just an unreasonable burden. The strongest argument for the manufacturers and wholesalers is that regulating their prices relative to the prices they charge in other states unreasonably burdens interstate commerce. Great explanation. They should actually get paid more for it in that explanation. I just can't even take a note out of that. Like we didn't learn anything. We just saw it. Okay. Great job, everyone. All right. Well, I'm standing up, feeling presidential. I'll read this one. This is. Does anyone know where this picture is taken of? Does anyone know? It's in Miami. It's a road.
No idea.
Well, we'll forever wonder. It's very beautiful. Right?
There's a glare on it that it helps that I can't really, no one can see it, I think. I don't know if I can see it.
All right. Well, yeah, Old Cutler. Hannah got it right. Hannah, you're the winner of the day by far. You've been killing it. That's impressive. It's Old Cutler Road. All right. Let us read. The childhood home of a former U.S. president is part of a national park located in a city. The National Park Service entered into a contract with an independent antique collector to acquire items owned by residents of the city during the former president's lifetime. According to the contract, the collector purchases items and then sells them to the Park Service at a price equal to the collector's costs, plus a 10% commission. Purchases by antique collectors are ordinarily subject to the sales tax of the state in which the city is located. The collectors filed suit in state court to enjoin collection of the tax on these purchases for the Park Service, claiming that the sales tax is unconstitutional as applied to them. Should the state court issue the injunction, I have to pause here. Does everyone in the class know what this word means?
Yeah, injunctive relief to stop, or sorry, to stop them from doing something.
Prevent.
To prevent, to stop. I know for people like, duh, why'd you say that? Because this is one of the big problems with this test, is that it's a vocab test, and on the actual test day itself, you're gonna see words that are tough. I think this is a tough word for non-lawyers because join seems like join. Enjoin means stop. Make sure you know that. To stop collection of the tax on these purchases. So how are we gonna do this? No, because as the purchaser of the antiques, the collector rather than the federal government is liable for the tax. No, because the suit is within the exclusive jurisdiction of the federal courts. Yes, because the federal government is contractually obligated to pay the amount of the sales tax when the government covers the collection cost of the antiques. Yes, because under the supremacy clause, the federal program to acquire the antiques preempts the state sales tax on the purchase of these items. Take them 30 seconds. All right, any answers? Everyone's rocking with A, yeah. And I made this specific example, I think, in class that like, if it's someone who's not obviously this, not obviously, but the state government cannot tax the federal government. The federal government is the big boss. Can't touch the federal government. They could run wires through your land, through a state's land. They could run their, oil through the land or whatever, and they could have a building and they're not being taxed. There are exceptions though when it's an indirect tax. Here's an example of an indirect tax. They're taxing the antique collector, not the government itself. Another example is when it's independent contractor who's like building something and he's purchasing the materials for himself, by himself, not the federal government. Indirect tax. Excellent job, Nicole. Love it. I'm impressed, Hannah, about the old Cutler thing. Okay, let's try this one. In this case, the court should hold the exclusion of aliens from the state award program is either constitutional or unconstitutional. Yeah, true Miamian for sure. I could ask you some real Miami questions, but I won't. All right, to encourage the growth of its population, a state established a program that awarded $1,000 to the parents of each child born within the state, provided that at the time of the child's birth, the mother and father of the newborn were citizens of the United States. A family are aliens? That's not grammatically right, right? A family are aliens? Okay, I just don't like that. A family are aliens who are, let's say there's a family of aliens who are permanent residents of the United States and have resided in the state for 3 years. When their first child was born 2 months ago, they applied for and were denied the $1,000 award by state officials on the sole ground that they are not citizens of the United States. The family filed suit in federal court contending that their exclusion from the award program was unconstitutional. Assume no federal statute addresses this question. Tough. So the reason is to encourage the growth of its population. you know, they have this program and they're discriminating, it seems to be based on alienage. They literally tell you it's alienage. I say this is tough because alienage is usually strict scrutiny, but there are certain exceptions. Okay, so is this constitutional? Because the 10th Amendment reserves to the states plenary authority over the spending of state funds. Constitutional because the state has a legitimate interest in encouraging the growth of its population, and a rational legislator could believe that families in which both parents are United citizens are more likely to stay in the state and contribute to the future prosperity than those in which one or both the parents are aliens. Unconstitutional because strict scrutiny governs judicial review of such state classification based on alienage, and the state cannot demonstrate that this classification is necessary to advance a compelling state interest. Unconstitutional because state classifications based on alienage are impermissible unless explicitly authorized by an act of Congress. Take a moment. I'm sorry. All right, any answers? Let's keep them coming. We have a lot of discrepancies. A lot of delegates. Okay. In this election, B was coming on as the early favorite, then C taking a big comeback. Anyone want to argue for B?
Yeah, for B, so because it's the state doing the discrimination, it's subject to like a legitimate interest. Whenever it's discrimination by the federal government, then it's strict scrutiny. So that's why I chose that one instead.
Okay. Let's see, we have Chelsea and then Nicole picking the BC answer. I don't tend to like two answer choices as a one answer choice. I don't think that usually works on test day, but creative. What about C? Anyone explain C?
Yeah, so it's alienage, so strict scrutiny. There's like only one exception, which is when it has to do with government function, and this is not a government function, so strict scrutiny.
Kind of like that. Anyone want to tear that down? Anyone?
I was the only one that chose D, but probably it's wrong, but I want to say why I chose it. I was thinking that Congress has like all the power for aliens, so that's why I thought it was D, if they authorize it, because if when the state do it, it's equal protection violation. So, right?
So I like what I can't remember.
Natalie said it.
Who is it?
Natalie.
Natalie. I like what Natalie was saying.
Yeah,
That this is alienage. This is going to be strict scrutiny. The only reason it wouldn't is the government function. And to my mind, government functions are being on a jury, being able to run for candidacy, or being able to vote. This is about, you know, just growing its population. So I think it would be strict scrutiny. And they didn't do that. You like C? Excellent. State laws on aliens are subject to strict scrutiny unless they demonstrate against alien and participation state government, like we said, in which case only rational basis review would be required. Since they cannot demonstrate that classification is necessary to advance a compelling state interest, will not pass strict scrutiny review. B is incorrect. Rational basis and incorrect level review, since it's a state law, alienage is suspect classification. So, you know, I think there's a little confusion in states or federal government. It doesn't matter. It's the federal government and the state are both subject to the confines and restrictions and parameters of the Constitution, right? And under the Constitution, we're going to have to apply strict scrutiny review here. And it's important to note, my favorite word on essays, strict scrutiny for alienage. It's important to note. I just love reading it. Rational basis for government functions. And we said vote, jury duty. Barbara was trying to tell me how great jury duty was. I was like, not for me. Vote, jury duty, and what's the other thing? Oh yeah, be a candidate. civic duty. No, I went and I got dismissed. Couldn't pay me enough to do that. My case was about this guy who was selling fentanyl. And he had to wear this thing in his ear that translated from English to Spanish. And all I could think is, I really want that device living in Miami so that every time I talk to people in Spanish, I was just like, that's all I could think about. But then they didn't pick me. All right, I'll read this one. Are the president's decisions constitutional? A federal statute provides the president must expend all funds appropriated by Congress, and that appropriated funds must be used only for the purposes named in the relevant Appropriations Act. An appropriation statute directs that 300 million be spent on planting wildflowers along public highways. How pretty. Considering the statute to be a waste of money, the president has announced 2 decisions. First, he will spend half of the money to train troops. Second, he will retain the remaining funds in the federal treasury and not spend them at all. Are the president's decisions constitutional? Both decisions are constitutional. Only decision to spend funds to train troops is constitutional. Only decision to retain the remaining funds is constitutional. Neither decision is constitutional. Let's take a moment. Robert would be excited for jury duty. Robert also served in the Air Force. He's a true hero. I'm just a guy working, just a working man. All right, what are our answer choices? Ooh. Only 2 answers and they conflict. CCD, CCD, CDD, B, ooh, D. D's coming in strong, the D delegation. Let's hear from the D delegation. What's wrong with it? Can this president spend differently than directed?
No, so need the Congress approval. That's why neither decision is constitutional. Is what I believe.
Excellent work. Excellent work. Who was that speaking? Oh, Pablo. Perfect.
Yeah, man.
Good job. You're right about that, right? You guys spend it on the wildflowers. Who are you to determine that the wildflowers aren't pretty enough? You want to spend it on troops? The take care clause, right, requires that the president take care that the laws be faithfully executed. Here, one of those laws is the requirement that all funds in question be spent on planting wildflowers. To keep the funds in the federal treasury would violate the legal mandate that all funds be spent. In addition, since the appropriation clause of Article 1 provides that federal spending be authorized by Congress, and the appropriation statute here directs the money to be spent on wildflowers, the president cannot use the money to train troops. Thus, neither decision is constitutional. So we have the take care clause and the, was it Appropriations Act? I'll take care of you, Ariana. Banger. Appropriations Act. One of my students said that I was weird, and I was like, I don't think so. I think you're weird for thinking that. So take care clause requires that you take care and faithfully execute the law, right? Take care and faithfully execute the law. And the Appropriations Act just means president must, how do they say it? Federal spending must be authorized by Congress. I like that even better. Be authorized by Congress. And then I would say if Congress directs, and what did they really do here? It was a statute that provides a president, yeah, appropriates. Appropriates president to spend money on wildflowers. He must spend them on wildflowers. Ooh, that was a very subtle mistake. We have to correct that. She must spend them on wildflowers. All right. Let's go.
Sorry,
As-
could you put the other, I didn't finish to write the note, sorry.
What do you want me to do?
The other, like, yeah, sorry.
All right, yeah.
She must spend them on what, okay, thank you.
Right, if we pass a law that the president must spend it on wildflowers, the president can't go and spend it on guns. As much as she would like to. Okay. As a matter of constitutional law, which of the following is the proper burden of persuasion in this suit? A state has a statute providing that an unsuccessful candidate in primary election for a party's nomination for elected public office may not become a candidate in the same office at the following general election by nominating petition or by write-in votes. A woman, let's go, sought her party's nomination for governor in the May primary election. After losing in the primary, the woman filed nominating petitions containing the requisite number of signatures to become a candidate for the office of governor in the following general election. The chief elections officer of the state refused to certify the women's petition solely because of the above statute. The woman then filed suit in federal district court challenging the constitutionality of the state statute. As a matter of constitutional law, which of the following is the burden of persuasion in this suit? The woman must demonstrate that the statute is not necessary to achieve a compelling state interest. The woman must demonstrate that the statute is not rationally related to a legitimate state interest. The state must demonstrate that the statute is the least restrictive means of achieving a compelling state interest. The state must demonstrate that the statute is rationally related to a legitimate state interest. Let's take a minute. What are you guys talking about in this chat? Drake? Drake? Oh yeah, Drake and Rihanna. Drake? Mr. Hide the baby from the world, but can't hide the world from the baby. All right, what do you think the answer is? A lot of C's, 3 G's, 4 C's, 4 C's. Any discrepancies? C's, C it is. C's get degrees. Everyone sees no. Ooh, okay. B, going with the majority. We don't like that. Don't do that, Pablo. Don't do that in life. Please. If you learn one thing from this class, don't just go with the majority. That's how you fall off cliffs. All right, Natalie, Hannah, okay. I want to hear B.
So it's the statute is not discriminating based on any like suspect classification, but I'm just not sure if right to vote would be like a fundamental right and get strict scrutiny. But if it's not right to vote, right to run, but I still think it's B because it's not a suspect classification. It's not discriminating because she's gender or any of those, so rationally related.
You definitely flipped the delegate from the C delegation. Now the B delegation is coming out strong. Okay.
Yeah, if you read the question, it's not based on her gender, so that's probably why people got confused. And then the state statute is also not discriminating based on any suspect or
Based on
quasi
gender would be intermediate scrutiny. So I think that's
Right.
not even necessarily relevant because none of these are intermediate scrutiny.
And it's
I-
not strict either because there's no suspect class.
It's
But
either-
I think there's a constitutional right to run.
That's the only part that confused me, yeah.
Meaning with Grace here that this is sorry, why did I do that? Why did I do that? I'm leaning with Grace here, but now the delegates are split. So I could be convinced. And I told you, Carlos,
She
not my
might, yeah, it's probably C. No, I'm keeping.
That's another thing. Don't
Stick with B. Stick with B because I'm sticking with B. Stick with B.
Whoa. Well, let me think through and pick my answer, please. I'm just messing with you, Chelsea. But what Omar's saying, freedom of association. Okay. Let's see. Iona, you've been doing well today, like every day. What's your argument for B? I'm trying to hear arguments. I'm leaning C, but I'm telling you as a fact, I'm trying to hear some arguments. What's about B? Iona or Barbara, maybe?
My thought process was the same as Natalie's in that it wasn't a gender restriction. And so then the burden would be on the woman to prove it's not rationally related. But then again, I was thinking maybe the right to be a candidate has some more fundamental. Yeah. So, but yeah, I would have put B.
I'm leaning C. Is anyone very, very passionately about B? I'm not very passionate about C. Not that I'm passionate about letters. I'm really in C. All right, C, go with your gut, everyone. Guts. Guts over glory.
Yeah, it's because of the fundamental right association or that stuff. Yeah.
It is indeed. Good job, Grace. All right, restriction on the ability of individuals to be candidates must be examined to determine whether they violate the First Amendment freedom. Oh, excellent. Omar, freedom, First Amendment. Good job, Omar. See, I'm all about positive reinforcement. That's why my dogs are so greatly trained. Violate the First Amendment freedoms regarding the association and expression of the 14th Amendment Equal Protection Clause. Right now, they're being perfect. Like, it just takes a little bit of time. Here, First Amendment rights are involved in the action because the statute infringes on the right of political association, the right of a political association. As a result, strict scrutiny is the appropriate level of review. Let's go to the extendo. In cases involving access to the ballot by political candidates, the U.S. Supreme Court typically determines whether the restriction at issue violates the First Amendment freedom of association or the 14th Amendment Equal Protection Clause. If the restriction infringes upon a fundamental right, such as the freedom of association, strict scrutiny will apply. In demonstrated support cases, where a state requires a candidate to win the primary before running in a general election, a balancing test applies. Here we go. In Timmins v. Twin Cities. The court stated that the process of weighing the character and magnitude of the burden the state's ruling imposes upon First and 14th Amendment rights, and then determining whether the interest justifies a severe burden. This is done by looking at whether the restriction is narrowly tailored to further their compelling interests. Okay, sounds like strict scrutiny to me. When the burdens are less severe, however, the scrutiny will also be less severe. In other words, is a case-by-case analysis. Oh, perfect. Look at Storer v. Brown, finding a demonstrated support restriction constitutional. Finding a demonstrated support restriction constitutional when a reasonable alternative means exists for a candidate to access the ballot without heavily burdening the right to associate or vote. If the restriction is reasonable and non-discriminatory, it generally be upheld on the basis of the state's important regulation interest. So it's very confusing. I'll try to dumb that down. Access to ballots is strict scrutiny, unless it's a case-by-case basis and it's not that difficult and it's like they're just requiring some procedural thing, like, you know, just you have to, you know, I can't
Like have an ID, for example.
exactly, like, yeah, you have to have an ID, or for example, or maybe on alienage, certainly that's rational basis. Like there's certainly things, but if it's like this scenario right here, it seemed like it was pretty much a stupid restriction. Like, what do you mean I can't be by petition or write-in votes? Like that's like a regular way you get voted in. Omar, go ahead, help us out here.
Yeah, so I think this question is kind of like if Andrew was running as a Democrat and then he lost, then he couldn't switch parties as an independent and then go run.
Wait, we're gonna slow that down. If Andrew was running as an independent, do not put me in either political party.
No, but just saying, regardless what party, let's say you were running and then you lose, but then in the next cycle you want to run as a different one, then they're telling you that you can't run.
Right, great example. If Andrew ran as a Democrat and then later ran as a Republican and there was some violation there, we got to stop using me in political alignment. I'm a registered independent. Let the record show. Okay. You got me on my toes.
So wait, one more time, Andrew. So what would be your rule statement for this?
That's what I was about to do. A big old rule statement.
All right.
Big old rule statement. Okay. Access to the ballot is strict scrutiny under First Amendment freedom of expression. I'll say there may be narrow exceptions if restriction is, and how did they say it? Under the extendo, reasonable and non-discriminatory. So, sorry, no offense to the Democrat or Republican Party. I think they're fine parties. I think they're two of the top 10 parties in America. Okay.
Andrew, what is the number of this question, please? In order to
The number of this question.
Yes.
703.
703. Thank you.
See, con law is hard because, again, it's very politically motivated. Some things don't make sense. Some things were during the Reagan administration. Some things were during the Obama administration. You know, they were never during an independent president. They were never during a lot of presidents. It's a lot of political things. Please don't hate me. I'm not a hater. I love everyone. You should all be president. Okay, next question. The number of large billboards along a city's major roadways has increased considerably in recent years. Many political groups have contributed to that increase with their growing use of billboards to display messages that further a variety of political candidates and public causes. The city council has received many complaints from residents claiming that the billboards are ugly and detract from picturesque sites along the roadways. In response to these complaints, the city council has enacted an ordinance that substantially limits the number and the size of the billboards that may be erected along designated scenic roadways. A company that owns many of the billboards affected by this ordinance has filed suit, claiming that the ordinance violates the company's freedom of speech. So going back similar to the first question, potentially. Should the court uphold the ordinance? No, because the ordinance burdens a political speech and is not necessary to further a compelling government interest. No, because the ordinance restricts speech in a traditional public forum. No, because the ordinance is narrowly tailored to further the substantial government interest in the city's appearance. And yes, because the ordinance reasonably regulates the use of public roadways. Let's take a second. Lexi was saying the performance stats are horrible. I couldn't even see the number because your beautiful faces are blocking it on my screen.
Like 30% or like 40% on it.
Yeah, that was tough. The access to the ballot one was tough. Generally, just apply strict scrutiny to access to the ballots. That's what I take away from it. And also that Andrew's an independent. Don't place me with any party, any cult. I'm an independent business owner. Support small business. Remember that small wave that crashed? All right, do we have any answers here? Okay, DCC, Dormant Commerce Clause. DCC, Dormant Commerce Clause. So we have D's and C's. Yes, because the ordinance is narrowly tailored to further substantial government interest in the city's appearance, or yes, because the ordinance reasonably regulates the use of public roadways. Anyone want to argue for the C or the D delegation? This is a very political class.
Yeah, it's I guess it would be a public forum and it's viewpoint and content neutral, so rational basis. So D.
Okay, anyone want to argue for C? Is it rational basis for time, place, and manner?
I thought it was intermediate.
Intermediate, but it's
Modified intermediate.
That was intermediate, but a heightened intermediate.
but isn't the only one it's
I thought.
content based?
Exactly, when it's neutral, I thought it was less.
It's never, I don't think it's ever rational basis for speech.
Okay, intermediate then.
Intermediate, I would apply here. So we have some C's. Anyone want to argue for C?
Exactly, C is intermediate, right?
Yeah. Reasonably regulates the use of public roadways. It's nearly tailored for the substantial government interest in the city's appearance.
It's a in neutral, content neutral, so it's
Intermediate.
intermediate scrutiny, exactly.
Right, we have billboards. And what are they saying? Number and size of the billboards, number and size. It's content neutral, intermediate scrutiny. I think it's fine. Anyone want to save me from C? You guys are getting too used to seeing green. We're going to see this red and it's going to be heartbreaking. Okay, C is correct. The ordinance is a content neutral. Now you got me curious about what's the rate? 62, okay. The ordinance is content neutral restriction on speech because it regulates without regard to the content of the message expressed on the billboards. Content neutral speech restrictions receive intermediate judicial scrutiny, which requires a restriction to be narrowly tailored to further substantial government interests. The Supreme Court has held that the aesthetics interests of a community are sufficiently substantial to justify content neutral restrictions on public displays of signs. See Metro Media versus San Diego. Stay classy, San Diego. The ordinance here is narrowly tailored because it applies only to scenic roadways and does not completely ban signs. So remember, time, place, and manner, this is how I'll talk about this one. Time, place, and manner is heightened intermediate scrutiny, which means important interest and narrowly tailored.
But only if it, what about only if it's in public forum or also in non-public forum?
In public forum, right?
I know, I have a question. The
May have an answer.
the standard of review changes if the law is content neutral or content based also.
Yes, of course. If it's content based, it's strict scrutiny. This is not.
What-
strict scrutiny.
What else do I have to take into consideration other than if it's content based and or content neutral?
If it's public or non-public forum.
Okay,
And then if it's non-public forum, it just has to be viewpoint neutral. Let's go. I'm just proud of myself because that's a hard concept and I actually understand it. I know I take small victories. I'm like, all right, let's continue. Poultry. When I was in college, they paid me $1 to watch this video of like chickens and it was so gross. I still to this day said I was going to be vegan by 40 because of me watching that one video. Yeah, $1 because we were college kids. $1 was a lot back then. It was like a slice of pizza, remember? Slice $1 a slice. That was like a hit song when I was in college. I love college. $1 slice really existed. But yeah, watch this video to see this chicken story. Yeesh. Okay. A fatal virus recently infected poultry in several nations. Some scientific evidence indicates that the virus can be transmitted from poultry to humans. Poultry farming is a major industry in several US states. In one such state, the legislature has enacted a law imposing a fee of 2 cents per bird on all poultry farming and processing operations in the state. The purpose of the fee is to pay for a state inspection system to ensure that no poultry raised or processed in the state is infected with the virus. A company that has poultry processing plants both in state and other states has sued to challenge the fee. Okay, 2 cents per bird on all processing plants in the state. No, because although it attaches to intrastate activity in the aggregate, the fee substantially affects interstate commerce. No, because it places an undue burden on interstate commerce in violation of the negative implications of the Commerce Clause. Yes, because it applies only to activities that take place wholly within the state and does not unduly burden interstate commerce. Yes, because it was enacted pursuant to the state's police power, which takes precedent over the negative implications of the Commerce Clause. Everyone take a moment to think about this one, because I think it's pretty tough, actually. Any answers? Mostly C's and 1A. Mostly C's. I'm leaning C too. Right, seems to be all within the state. It doesn't seem to discriminate against anyone. It's just saying totally within the state, and the purpose of this is to protect things in the state from the virus. It doesn't seem interstate. It only affects in-state stuff, is what Paul's saying. Iona, you picked A?
Hi, can you hear me? Sorry, I had to switch to my phone. The reason I chose A is because I thought, even though it is affecting only the state, I thought it might be reasonable to think that the chicken would not stay in the state. But that was just my thought process, but I can understand why C is also the answer.
I mean, I'll be honest, A, B, and C all have merit or are tasty, right? Because A is like, yeah, that's a Commerce Clause answer. That's a tasty answer on the test. B, true, like, are they, impacting interstate commerce? Because it does say they own operations outside the state and la-di-da-di-da. But then C seems to just be like the answer here. I don't know.
what about E?
What about D? Yes,
Because police power, it takes care of the health, right?
no, but D just is a gross answer. No offense to D, but just says, which takes
No offense.
over the negative implications of Commerce Clause. Like, I just think that's wrong. The state's police power does not take precedence over the negative implications. So I just think that can't be the answer. I just think that's
Oh, okay, I get it.
that's why I said it was a gross answer. Like, ew, like that's not even a true statement of law. Can't be the answer. But A, B, and C seem reasonable. I didn't mean to pick on you. I'm sorry. I wasn't picking on you like that. Grace. We go back.
I know, don't worry.
I'm rocking with C. C's get degrees. That's the old saying goes. See, if this would have been wrong, I would have been like, this question is a good egg. I don't know what that means. The fee does not violate the negative implications of the Commerce Clause because it's not discriminating against interstate commerce, and its undue burden on interstate commerce, if any, does not outweigh the legitimate public health effect inspection system will bring to the state. That's true. I'm going to read the extended explanation. It's going to go over a lot of people's heads, but just know this is how the Dormant Commerce Clause works. It either has to not discriminate against or not unduly burden. But if it does unduly burden, then it's subject to a balancing test, right? And typically the balancing test goes in favor of it unduly burdens. This is question number 1588. Okay, someone asked me that. People out there listening, I just randomly said that. Okay, the Commerce Clause grants Congress the power to regulate commerce among the states, and that power also creates a limitation on each state's ability to pass laws that affect interstate commerce. That limit is called the Dormant Commerce Clause. Under it, states cannot pass regulations of local aspects of interstate commerce unless they do not discriminate against out-of-state parties to benefit local economic interests and are not unduly burdensome. When a state regulation does not discriminate, but merely burdens interstate commerce, it may be upheld based on a case-by-case balancing of the legitimate state interest versus the burden of the interstate interest. That's the takeaway from this question. It's a tough takeaway. The state's poultry fee does not discriminate against out-of-state commerce because it applies only to in-state farming and processing operations, which means the court will first determine whether it burdens interstate commerce at all. The facts do not indicate such a burden because the poultry fee applies only to interstate commerce and does not regulate activities that occur outside its borders. Even if the fee did burden interstate commerce, however, the court would apply a balancing test measuring the legitimate state interest versus the burden on interstate commerce. There's no indication that the fee would fail that balancing test because the burden, if any, does not outweigh the significant state interest of protecting the citizens and their food supply from a potentially fatal cross-species virus. Thus, the fee is permissible under the Dormant Commerce Clause. If we go to this, we should say under Dormant Commerce Clause, state law cannot discriminate interstate commerce or unduly burden interstate commerce. Sorry. And if it unduly burdens, it is subject to a balancing test of burden versus state interest. I mean, that's fair enough for us to just kind of understand.
Andrew, if it does discriminate, then what's the next thing?
So if it does discriminate, then it violates it, right?
And then that's the end of it? All right.
Yeah. When it does discriminate, it's just, yeah, you're out. Red flag. This is more like a yellow flag, a yellow card. Yellow card, that's what I meant. See, I didn't grow up playing soccer. I should have. I like soccer, football. I taught during the World Cup, never missed a class. Taught during the Super Bowl, never missed a class. Dedicated to my practice. All right. Pursuant to an arrest warrant issued by a federal judge, FBI agents arrest a state. Oh, sweet, Brian. Pursuant to an arrest warrant issued by a federal judge, FBI agents arrested a state governor for an alleged violation of federal law. The governor was then placed in a federal lockup facility. A state judge has issued a writ of habeas corpus against the director of the lockup facility on the ground that the federal law in question violates the 10th Amendment. Is the writ valid? A writ of habeas corpus. Bring me to body, right? No, because only federal courts can issue habeas writs for individuals in federal custody. No, because the arrest was made pursuant to a warrant. No, because state sovereignty shields the governor from federal coercion. Yes, because Constitution guarantees the availability of habeas corpus. All right, take a minute. Anyone know the answer? Not A's. A's. Brian, what do you think it is? Hey, yeah, I was waiting for Brighton. He's like, this is in our questionnaire. Right, this was, right? Only federal courts can issue writs for habeas corpus in federal custody. The supremacy clause prohibits states from issuing habeas writs that interfere with federal detention. So state cannot issue federal habeas corpus. Simple. Any questions? This test is tough because it's like little things, like it'll be like la 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 la, and then the president pardons Tommy for something, and then you realize it's a state crime, and the president can't pardon for state crimes, and like you just weren't focused on that little tiny detail. So that's what makes it a tough test, is just knowing how to zero in on some tiny deets. Okay, I feel like today's been like an interesting class. I don't know why. A clerical employee of a city water department was responsible for sending out water bills to customers. His work in this respect had always been satisfactory. The employee's sister ran in a recent election against the incumbent mayor, but she lost. The employee had supported his sister in the election campaign. After the mayor found out about this, she fired the employee solely because his support for the sister indicated that he was disloyal to the mayor. This is in my cram guide. The city's charters provide that all employees of the city work at the pleasure of the mayor. Is the mayor's action constitutional? No, because public employees have property interest in their employment, which gives them a right to a hearing prior to discharge. No, because the mayor's actions violate the employee's right to freedom of expression and association. Yes, because the employee has no property interest in his job since the city charter provides that he holds the job at the pleasure of the mayor. Yes, because the mayor may require members of her administration to be politically loyal to her. Okay. Any answers here? B's and A's. B's and A's. B's are coming on strong. The B delegation. Let's hear from the B delegation. Nobody from the B delegation? How about Paul? Issa's saying he has a right to associate with his sister. Yeah, right.
Also, the job he doesn't has anything to do with his expression.
100%. Perfect. That it doesn't have anything to do with his ability to perform his job, right? If the loyalty to the mayor had something to do with his job, but he could still do his job. I like this, you know, this is a, D is like Coach Boone in Remember the Titans. That's the vibes I'm rocking with, but that's not the mayor. That's the football coach. We want to know why A is incorrect. I'm sorry. Yeah, zero fun, sir. B is correct. The political views or affiliations of a clerical employee of a city water department are not relevant to the employee's job, and thus the employee may not be fired because of them. A is incorrect. A public employee has a property interest in his or her employment if the employee can be fired only for cause. Because the clerical employee signed a charter to work at the pleasure of the mayor, there's no property interest in his employment. That's important to note, right? You have a property interest in a state job if you are fired, if you must be fired for cause. For instance, if you work at the pleasure of the mayor, you do not have a property interest. Can anyone give me a good example of someone who does have a property interest in their job?
A tenured professor.
I say that tenured professors, and if these law schools will stop playing with me, no, I'm just kidding. I can become a tenured professor. If a tenured professor does at a public university, obviously. I'm just kidding. Law schools aren't playing with me. They couldn't play with me if they wanted to. A tenured professor at a public university does not have a property interest. I mean, does have a property interest. I'm very sorry. Does, because you're tenured. That's what tenure is. That's why, did anyone go to University of Miami? Anyone ever had Professor Langbine in law school? I always tell people, if you go to UM Law School, take Professor Langbine, my favorite professor, because he is tenured and he knows they can't fire him, and his course is super chill. And it's tough, bankruptcy and secure transactions, you know, he teaches important stuff. But he's just like, look, I'm tenured, I'm teaching. You guys are going to listen and learn or not? I could care less. And me, I listened and learned, but most people cared less. But he was cool. Everyone got good grades in his class, which is why we took it. All right. A new federal statute. Oh, did I want to write something else about this? Yeah, which was, let's say you cannot be fired for voting for a candidate unless it affects your ability to do your job, i.e. the mayor example. I think we can all remember this example. If not, that'll be a useless point. Okay, which of any of the following methods of appointing the commission members would be constitutional? A new federal statute establishes a 5-member commission on cultural heritage sites. The statute directs the commission to develop regulations to protect such sites on federal public lands and to implement the regulations through specified fact-finding and adjudicatory functions. The commission is not under the supervision or control of any federal agency. Which of the following methods of appointing commission members would be constitutional? Members are appointed by a specially designated panel of federal judges. Members are appointed by the Speaker of the House of Representatives with the advice and consent of both houses of Congress. Members are appointed by the President with the advice and consent of the Senate. None of these appointment methods would be constitutional. Let's take a moment to think. Okay, what answers do we have? 1C. Participation is dwindling. C's and D's. There's some notably quiet members of the audience. I know you might be shy, but no one cares. I'm not like reading out who picked what. And trust me, this recording is not going to be part of our like public recordings because I was like walking up and down, my dogs are crying, so feel free to stretch your voice. All right, we're going with C's mostly, big C's. Big C's, why? Because yes, appointment, that's a presidential power, appointment powers, removal powers, commander-in-chief, the power to, no, I'm done taking rips at any former presidents. I feel like I've said too much. Okay, any former or current presidents. All right, C is correct. The commission exercises significant legal authority, namely the authority to adopt and enforce regulations. For that reason, the commissioners are officers of the United States. They're not under any federal agency, so they're not considered inferior officers and must therefore, pursuant to the Appointments Clause, be appointed by the president with the advice and consent of the Senate. So let's say that commissioners are officers of the United States. Commissioners are officers of the US and must be appointed by the president, no, let me call capital, with consent of Congress, right? Remember appointment powers, removal powers, commander-in-chiefy powers. Okay. I was just thinking, I think, was it Lexi that said Robert is on jury duty?
Yeah, he got like called on Friday, so we had to reschedule our stuff. And he hasn't texted me to tell me if he got it or not because he was really, really excited. He's like, I hope I get to stay, but he's worried since he's like barred and stuff that they'll kick him out.
Yeah, no, he has no chance because he's also a veteran, if it has anything to do with any veteran issue or anything. I don't know, not want to say no chance, but usually they wouldn't pick a guy like him who teaches the law. Like, no way.
And he'll be sitting there probably smiling and they'll be like, what is up with him? He looks way too happy to be here.
Yeah. Robert's a good guy, man. My staff is awesome. Everyone on my staff is awesome. 5-star staff. All right. Congress recently enacted a statute creating a program that made federal loans available to family farmers who have been able to obtain loans from private lenders. Congress appropriated a fixed sum of money to fund loans made pursuant to the program and gave a designated federal agency discretion to decide which applicants were to receive the loans. 2 weeks after the program was established, a family farmer applied to the agency for a loan. Agency officials promptly reviewed her application and summarily denied it. Oh, they denied this family farmer? This farmer has sued the agency in federal district court, claiming only that the denial of her application without the opportunity for a hearing violated due process clause of the 5th Amendment. So does this lady deserve a hearing, this family farmer? The farmer claims that she could have proved at such a hearing that without a federal loan, it would be necessary to sell her farm. Yikes. I want to get into the exotic fruit tree business. Congress recently enacted a statute creating a program that made federal loans available to family farmers who were unable to obtain loans from private lenders. They appropriated the money to fund the loans pursuant to a program, and this is what I'm looking at. A designated federal agency had discretion to decide which applicants would receive the loans. Is that cool or not? And is she entitled to a hearing? That's what we're looking at. Let us see. No, because due process requires federal agencies to provide a hearing before making any factual determination that adversely affects an identified individual on the basis of his or her particular circumstances. No, because the denial of a loan may deprive the farmer of an established liberty interest pursuant to her chosen occupation. It's a ginger ale, by the way, don't you think? Yes, because the applicable statute gives the farmer no legitimate claim of entitlement to receive a loan. And yes, because the spending clause of Article 1, Section 8 gives Congress plenary power to control the distribution of appropriated funds in any manner it wishes. Take care, Brian. See you after. What do we think? Take a minute. Well, fine. Let's just answer this question. Yeah, mostly C's are coming in. Yeah, I think C's are coming in hard. Right, 1A, and I'm going to dispute A because I think this is fair. My question was this: is this fair? Yeah, they gave an application and they had an agency who reviewed or denied it. Trust me, I've applied for a lot of things that I was denied for that I thought I should have got, and I didn't get a hearing each time. And if I would have got a hearing, I would have brought Robert and Matt Beckerman, I'd have brought the team with me, but they didn't give me that time. Yeah, there's no legitimate claim here, right? The court should uphold the agency's decision because the due process clause did not require the government to provide the farmer with an opportunity for administrative hearing on her loan application. The farmer had no legitimate claim of entitlement to a loan because the statute gave the agency discretion to decide which applicants would receive the loans. The agency's denial of the farmer application therefore did not deprive her property or liberty interests protected by due process clause. So we'll just make this easy. Am I still sharing? Yeah. Easy. I'm just saying I'll word it for us. I would say that a federal agency can have discretion on who receives a loan or funding, and that person does not have a right to notice or hearing. Cool. Cool beans.
That will depend on what the statute says.
Yeah, for sure. I mean, if it's some ridiculous statute that they deserve a notice and hearing, but here, there's no legitimate claim. They had discretion. It was gravy. Okay. Oh, I want to do this one because I think this is the Ybor City example. A city's zoning ordinance contains provision restricting places of adult entertainment to 2 specified city blocks within the commercial center of the city. These provisions of the ordinance define adult entertainment as live or film nudity or sexual activity, real or stimulated of indecent nature. A business owner proposes to operate an adult entertainment establishment outside the 2-block area zoned for such establishments, but within the commercial center of her city. When his application for permission to do so is rejected solely because it's inconsistent with provisions of the zoning ordinance, he sues the appropriate officials of the city, seeking to enjoin them from enforcing the adult entertainment provisions of the ordinance against him. He asserts that these provisions of the ordinance violate the First Amendment and made applicable to the city by the 14th Amendment. In this case, the court hearing the business owner's request for an injunction would probably hold that adult entertainment provisions of the city zoning ordinance are constitutional because they do not prohibit adult entertainment everywhere in the city, and the city has a substantial interest in keeping the major parts of its commercial center free of uses it considers harmful to that area. Constitutional because adult entertainment of the kind described in these provisions of the city ordinance is not protected by the free speech guarantee of the First and 14th Amendment. Unconstitutional because they prohibit the commercial area of the city adult entertainment that is not obscene within the meaning of the First and 14th Amendments. Unconstitutional because zoning ordinance that restrict freedom of speech may be justified only by a substantial interest in preserving the quality of a community's residential neighborhoods. So what do we think about this one? We can drop answers. I'll pick up the pace a little bit, if y'all don't mind. Mostly A's, and by mostly I mean 100% A's. Why? Because all you guys are going to Ybor City and hanging out instead of studying. No, but we understand this concept, right? That like a city is allowed to time, place, and manner strip clubs. I think that's like the easiest way of explaining it. A city may time, place, and manner strip clubs. Wow, they explain it the same way. A city may time, place, and manner may limit the time, place, and manner of adult businesses as long as restrictions allow enough avenues of expression and protect against the secondary effects caused by such businesses. The ordinance does just that, and therefore it's constitutional. So in Andrew speak, I'm going to say a city may time, place, and manner strip clubs, which like Ybor City. I did a presentation in law school about how strip clubs really, are a vehicle for human trafficking, right? And it was a super awesome presentation, very convincing. And like all the girls in my class's boyfriends got mad at me, like, now I can't go to a strip club with your stupid presentation. I was like, well, I was just trying to get an A, and I knew the teacher would like it. Like, what do you want me to do? All right, let's go again. Lookalike drugs is a term used to describe non-prescription drugs that look like narcotic drugs and are sold on the streets as narcotic drugs. After extensive hearings, Congress concluded that the sale of lookalike drugs was widespread in this country and was creating severe health and law enforcement problems. To combat these problems, Congress enacted a comprehensive statute that regulates the manufacture, distribution, and sale of all non-prescription drugs in the United States. Which of the following sources of constitutional authority can most easily be used to justify the authority of Congress to enact the statute? The spending power, the Commerce Clause, the General Welfare Clause, or the enforcement powers of the 14th Amendment? No, Grace, absolutely not. There's only one spot I celebrate people passing the bar at. Oh, two. Flanagan's or Monty's? All right, what do we think the answer is? A lot of bees. Bees in the trap, the beehive. Right, Commerce Clause, strong answer. Like Andrew, I always tell people whenever their name is Andrew, I always say strong name. That's like an inside joke we have. The power granted to Congress to regulate commerce has been interrupted so broadly that encompasses almost any economic activity that conceivably have some kind of impact, even secondary on the stream of commerce. Because the sale of these drugs was widespread throughout the country, and the statute targeted the sale, manufacture, and distribution of drugs properly authorized under the Commerce Clause. So as we can say is the sale of drugs can be regulated under the Commerce Clause. Now, not if there is a grass growing, not just a grass, a special grass growing that is so widespread that it has no commercial value, right? Or market. Right here, there's a commercial value in market, prescription drugs. It's like the biggest market in American history. But there's a question that you'll see. There's a grass that's growing on the ground and there's no commercial market for it. You can make a tea and it gets you all twisted. But if there's no commercial market for it, then they can't regulate it. Commerce Clause, it has to be commerce. I know that seems obvious, but it's not as obvious as it may seem. Okie dokie. A valid treaty between the United States and a foreign country provides for the elimination of all tariff barriers between the two countries. It authorizes the president of either country to issue a proclamation nullifying any state or local laws in that country that have the effect of impeding imports from the other country. The foreign country uses the metric system of measurement. I have a point on this. And thus all goods produced there and exported to the United States are packaged in metric sizes such as liters and kilograms. A law of a state in the United States requires all goods sold in that state to be packaged in traditional American sizes, such as quarts or pounds. Because the state law substantially impedes imports from the foreign country, the President of the United States has issued a proclamation nullifying the state law pursuant to the treaty. Is the president's proclamation valid? It's a tough one. No, because the Constitution vests in Congress the exclusive authority to specify binding legal standards for weights and measures, and the president therefore lacks constitutional authority for this proclamation. No, because the principles of federalism embedded in the Constitution prohibit the president from taking action to invalidate a state law. Yes, because it's authorized by a valid treaty of the United States, it is not prohibited by any provision of the Constitution, and is therefore the supreme law of the land. Yes, because the president has inherent authority to nullify any state law that substantially impedes commerce between the United States and another country. Everyone take a minute to think about this, or 30 seconds. All right, what do you think the answers are? C's, A, C, A, C, 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 C. C's get degrees. Yeah, right. Constitution is the big dog, top of the totem pole. Then we have treaties and federal law, and they're pretty much equal, but if they conflict with each other, it's whatever was enacted most recently. Then we have state law, then we have all the little guys underneath that. But treaties, big dog. My point about this question is, why is it in the United States that everything is in, quarts and pounds, whatever, except drugs are like metric system? Like whenever I'm doing a drug question, it's like the officer found 28 grams of whatever. Like, isn't that weird that we use metric system for drugs in the United States, but nothing else really?
Yes, it's weird.
Thank you. That's all I wanted. Appreciate you guys. C is correct. Just as any federally enacted federal law, treaties are the supreme law of the land. Any state action or in conflict of U.S. treaty is invalid. Therefore, the president's proclamation nullifying state law and the treaty is invalid. The supremacy clause invalidates any state action that is contrary to enacted federal law. Clause ensures that the U.S. Constitution and federal laws made pursuant to it constitute the supreme law of the land. It prohibits states from interfering with the federal government's exercise of legislative and constitutional powers. When both the state and federal government pass legislation in the area, preemption arises. Express preemption, right? Under Article 2, Section 2, Clause 2, Chapter 2, Verse 2, the treaty power is granted to the president by and with the advice and consent of the Senate, provided that 2/3 of the senators present concur. Unlike other federal law, treaties are the supreme law of the land. Any state action or law in conflict with the U.S. treaty is invalid, regardless of whether state law or state contractual provision, constitutional provision. The president's proclamation nullifying the state law in a treaty is valid because just like any federal law, a treaty is the supreme law of the land and prevail as long as not otherwise unconstitutional. All right, watch how I do this one. I'm gonna create a totem pole. So this is do you remember totem poles? They still exist? I'm just kidding, of course they still exist. So totem pole. At the top is the Constitution. Then tied neck and neck is treaty and federal law. Most recent prevails. Then state law. So we can say, I'll use this little thing. Federal law and treaties are the supreme law of the land. Don't get treaties confused with executive agreements, which are just, the president without ratification. All right. A professional motorcycle rider who put on a performance in a privately owned stadium during which he leaped his motorcycle over 21 automobiles. What's that guy's name? What's that guy's name that everyone knows that does this? He's dead, but his son still does it. His name sounds like it. Yeah, Evel Knievel, thank you. Needed that. A professional motorcycle rider put on a motorcycle in a privately owned stadium during which he leaped his motorcycle over 21 automobiles. Spectators were charged $5 each to view the jump and were prohibited from using cameras. However, the local television station filmed the whole event from within the stadium without the knowledge or consent of the rider and showed the film in its entirety on the evening newscast that day. The rider therefore brought suit to recover damages from the station for the admittedly unauthorized filming and broadcasting of the act. The television raised only constitutional defenses. Tough question, I think. The court should hold against the rider because the First and 14th Amendment authorized press coverage of newsworthy entertainment events. Hold against the rider because the First and 14th Amendments newscast broadcasts are absolutely privileged. Find the station liable because the action deprives the rider of his property without due process. Find the station liable because the First and 14th Amendments do not deprive an entertainer of the commercial value of his or her performances. Let's take a second to think this one through. All right, what do you think it is? C, D, 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 C, D, 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 D. I like D, right? I don't think we're going to deprive Evel Knievel of his value. Yeah, mostly D's. D's. Allegedly, D's do not get degrees. I feel like they should, though. They still passed. I guess they didn't have a requisite GPA. D is correct. The television station does not have any constitutional immunity from being liable in tort when deprives someone of the commercial value of his or her performance. Let's look at the extended explanation. Wow, I've done this question 4 times. The U.S. Supreme Court has held that broadcasting a performance and by extension appropriating the actions by the performer is not protected in the First Amendment. Right? Simple as that. D is correct. Despite the fact that the television station has a First and 14th Amendment right to publish information, it does not have immunity under the Constitution for liability and tort if it deprives a person of commercial value of that person's performance. So a TV station cannot claim a First and 14th defense for depriving someone of their commercial right value of their property. Of their performance, let's say. Let's just say that way. Right? You all, if you're depriving me of the commercial value of my work and you show it to other people, I wouldn't really mind because you'd be low key helping me grow my business. I got bigger fish to fry. All right, let's see. A mineral is added to bodies of fresh water to prevent the spread of certain freshwater parasites. The presence of those parasites threatens the health of organisms living in rivers and streams throughout the country and imperils the freshwater commercial fishing industry. The mineral currently is mined only in one particular state. In order to raise revenue, Congress recently enacted a statute providing for the imposition of a $100 tax.
Recording in.
Sorry, Jay. A $100 tax on each ton of mineral that is mined in the United States. Because it will raise the cost of the mineral, the tax is likely to reduce the amount of the mineral that is added to freshwater rivers and streams, and therefore is unlikely to have an adverse effect on the interstate freshwater commercial fishing industry. The mineral producers in the state have filed a lawsuit in federal court challenging this tax solely on constitutional grounds. Is the tax constitutional? No, because only producers in the state will pay the tax, and therefore it is not uniform among the states and denies mineral producers the equal protection of the laws. No, because it is likely to have an adverse effect on the freshwater commercial fishing industry, and Congress has a responsibility under the clause to protect, foster, and advance such interstate industries. Yes, because the tax is a necessary and proper means of exercising federal authority over the navigable waters of the United States. Yes, because the power of Congress to impose taxes is plenary. This tax does not contain any provisions extraneous to tax needs or purposes, and is not barred by any prohibitory language in the Constitution. Everyone take a minute to go through this because I need a minute to. All right, what do we think here? Mostly D's and then C, mostly D's. I'm not gonna lie, I was between D and C and then I lean towards D. I don't think this is navigable waters of the United States. It seems like an intrastate, it's only in one particular state. I think C is not a horrible argument, but again, necessary and proper is never gonna be the good answer here. Like, I just don't like that answer. I think it's gonna be power to tax and spend, or Commerce Clause. So if I had to choose between D and C, I would go D. Yeah, that's a good way of thinking about it. C is incorrect. The tax is justified under taxing power, not as a subsidiary to the power to control the navigable waters of the United States. Okay, D is correct. Congress's power to tax is plenary, and the tax measure will be upheld if it bears any reasonable relation to the goal and revenue generation. The statute does not contain provisions extraneous to tax purposes and does not violate any other section of the Constitution. So extraneous to tax purposes and violating the Constitution. So tax will be upheld if its components are not extraneous to tax purposes. And what do we say? And it does not violate the Constitution. So basically, broad taxing powers. Be very hesitant to say that they don't have the power to tax or spend. And then, as Iona is saying, is true. The necessary and proper clause doesn't stand on its own correct. It's always attached to something else. That's true. They have the power to do what's necessary and proper to, you know, take care of the land, but they have to, and that they have to act through some enumerated power, which is usually going to be the Commerce Clause or the taxing and spending power. If it's acting as a shield, it would be Dormant Commerce Clause. That's a good way of thinking of, not a good way, it's a decent way of thinking about Commerce Clause versus Dormant Commerce Clause. Commerce Clause is a sword that you're striking. Well, you're acting, you're creating a law, and Dormant Commerce Clause is a shield. You're protecting the interstate from a state enacting a law. I don't love that metaphor, so you don't have to run with it. I have some metaphors that I like. Life is just a dream. Row your boat down the stream. Okay, with the advice and consent of the Senate, the president entered into a self-executing treaty with a foreign country. The treaty provided that citizens of both nations were required to pay whatever tort damages were awarded against them by a court of either nation. A man and a woman who were U.S. citizens and residents of the same state were traveling separately in the foreign country when the cars collided. The foreign court awarded the woman a judgment for $500,000 and damages for her injuries from the accident. The woman filed suit against the man in federal district court in the home state to enforce the judgment. The man filed a motion to dismiss for lack of jurisdiction. It's got some civil procedure elements to this one. Should the court grant the motion to dismiss? Yes, because the citizenship of the parties is not diverse. Yes, because the traffic incident was a non-commercial transaction outside interstate commerce. No, because it falls within the federal jurisdiction of the court. No, because the treaty power is plenary and not subject to judicial review. Tough question. I think I got this one wrong before. Any answers? C. Issa saying C. Joanna saying C. EJ saying C. I like C too. I think because it falls under the treaty. What I highlighted says that the treaty regulates this, and if it's something that falls under a treaty, it's federal question. That's what federal question really means. Excellent. See, I got this wrong twice. Third time's a charm. So again, don't be like, wow, we're getting all these questions right. This is a learning exercise. I'm not expecting everyone to be doing very well at all. I'm expecting everyone to be learning and recognizing that they have work to do and keep hammering away. And this is, I love this. I love seeing that. Okay, C is correct. The motion should be denied because under Article 3, federal courts have federal question jurisdiction over cases arising under a treaty of the United States, as is the case here. See, only 41% of people got that right. I get it right 33% times. So federal courts have jurisdiction over cases arising under federal treaties. For example, if there is a treaty that regulates tort liability for accidents between citizens in foreign countries. I'm gonna admit this on live camera. When I was like 19 or maybe 17, I was in high school, like 17 years old. My friends and I went to Montreal because my brother went to the University of Vermont. We drove up to Montreal and I was driving and I drove the wrong way down a one-way and I got pulled over by a cop, but they only spoke French there. And like, we just couldn't speak to each other. And then he just let me go. He's like, all right, you dumb American. And I was like, okay, time for us to go back to the United States. So true story. I have a lot of good stories in my day. Okay, we gotta be close to 25 here. Congress enacted a statute prohibiting discrimination in the rental. Oh, I talk about this one all the time. I love when I talk about things all the time, then we get the question. That's true joy. So Congress enacted a statute prohibiting discrimination in the rental of residential property anywhere in the United States on the basis of sexual orientation or preference by any person or entity, public or private. Which of the following provisions provides the strongest basis for Congress's authority to enact the statute? The enforcement clause of the 14th Amendment, privileges and immunities of Article 4, Commerce Clause of Article 1, Section 8, or General Welfare Clause of Article 1, Section 8. Anyone know the answer? CCC, some A's. Right. I might have, there's another question where they give you 13th Amendment as an answer and you're tempted to pick it because it could be the answer if they were discriminating based on race. But under sexual orientation and in several aggregates, we're going to say that this is a Commerce Clause issue. Hopefully. Yeah. C is correct. The statute regulating residential property terms, although it may individually occur interstate, relates to economic activity that in the aggregate has substantial effect on interstate commerce. The strongest basis for the statute's constitutionality, therefore, is the plenary congressional power to regulate the interstate commerce. See, there's a court decision that says specifically, see, in there, in Gonzalez v. Reich, but I'm looking for the one specifically. Maybe it says it on a different question, but we can just analyze it as federal government may regulate housing discrimination laws based on sexual orientation, for example. Under Commerce Clause. I feel like we're getting right to 25. My spidey senses are tingling. Let's see. Gotta be done soon. Go a little quicker. In response to a nationwide increase in drug-related crime, Congress passed a statute creating a new agency responsible for enforcing federal drug laws. The statute authorizes the president to appoint the agency's director with the advice and consent of the Senate and prohibits the president from removing the director without the state's consent. The president appointed director and the Senate confirmed the appointment. Recently, the president has become dissatisfied with the director's strict approach to a drug law enforcement and wishes to remove the director. Because the majorities of senators favor strict drug law enforcement, the Senate has refused to consent to the director's removal. So the statute prohibits the president from removing the director without the state's consent. Is that going to be okay? May the president constitutionally remove the director without the state's consent? No, because Congress created the director position may properly impose conditions for the director's appointment and removal. No, because the president's removal of principal officers of the United States is subject to advice and consent of the Senate. Yes, because congressional participation in decisions to remove a presidential appointee violates the separation of powers. Yes, because Congress cannot limit the ability of the president to remove any employee of the executive branch. Any thoughts? A lot of C's. I'm not sure I agree with C, to be honest. Does everyone out there agree with C? D. I might agree with C, but I'm not sure I do. A lot of silence. I feel like this is a question that might stump us all. C or D, okay. Flipper. Anyone else? D question mark? Any other thoughts? No one thinks B? As in basketball? Okay, Barbara thinks B. D as in dog. Needs approval to a point. I know that. I agree with you, but not sure about removal. I'm with you, Lisa. And no pardoning power is absolute. Is removal power absolute? Or does he need consent? And here it even says in the statute. So you got some B's, some D's, and some B's. I think we're gonna get this one wrong as a team because I'm not really sure, honestly. And no one out there is giving me much confidence. Okay, B's, I give up. All right. Congress created, okay, so we know A is incorrect. We're gonna eliminate A. The president's removal of principal powers is subject to advice and consent of the Senate. That does say it in the statute. We'll consider that. Congressional participation. I'm gonna be honest, I don't really like C. C was a strong answer for, we had 4 C's out the gate, but I don't really like C. Anyone want to argue for C?
Yeah, the president can appoint him and remove him. So without, the Congress participation, that's what I believe. So
But I
I
think
just
you can, but
So I just think D says any employee of the executive branch, and I think that's wrong. So I think is yes. So that's why I just went with C instead. 'Cause I think D is too strong with the word any.
okay, you're not wrong about that. Any is a strong word. Kind of makes me think B, subject to advice and consent of the Senate, as it says, reading comprehension, removal. You agree with Omar? What did Omar pick? C.
I picked C too because I thought about any is a strong word and C goes straight to the point, separation of powers. Also, what Pablo said, I think that's the rule that he can appoint and remove.
I know we can appoint and remove. We did a question literally earlier today, which confirmed that you can appoint subject to the consent, which makes me believe that you kind of needed to remove.
But
Since-
what I'm thinking is that this law is about execution of the law. So that's a power of the president. So that adding to what Omar said.
He's become dissatisfied with the guy. He wants to remove him. I mean, let's think about this. This is why I'm leaning B here, and I could be totally wrong about this. Don't you think Trump wanted to remove the vaccine guy? What was his name? Fauci? From my understanding, he didn't like him very much, but he never removed him.
but he
Right?
never did it.
But if he could have, wouldn't he have done it, or would he have had to have? He could have just done it by himself with no consent if he wanted to. They do that. I mean, my gut was originally telling me D, that they cannot limit it. But then you're right about that any employee thing kind of makes me lean towards B. I'm leaning B right now which I don't usually do. I don't usually change my gut. I'm going to change my gut to B and probably get it wrong for the class. But if it is C, then congratulations to everyone who thought it was C. Is that cool with the class? I pick B here. I'm only human after all. I know, I see, my gut was C. All right, I'm only human after all. All right, C is correct. The Supreme Court has repeatedly held that Congress shall not play any role in the removal of executive officers. We as a class, July 2023, will never forget this. We will never learn this. I'm mad that nobody out there saved me. You guys all had the chance. I've gotten this question wrong 3 times now, and I picked every answer with C. So let's know that this is a tough question, and it's not that tough. I literally have said this in class that removal power is absolute, and I didn't listen to my own.
I think it's the wording of C that makes it hard to pick.
Nah.
The wording is really bad on C.
Removal power of president is absolute. It's not any of the wording, it's us. We did that to ourselves. But you know why I'm happy it happened? Because we'll never forget that, right? And if that moment where I had to embarrass myself on live TV for you all to learn this is very important to me, right? The Supreme Court has repeatedly held that Congress shall not play any role in the removal of officers, right? Absolutely. Whoever said this, any employee thing got me. I'll be honest. That killed me. Oh, shoot, wait, no, the answer was C, not D. Oh, I'm totally wrong. Good job, Grace and the committee. Okay, so let's understand this. Congressional participation in the decision to remove a principle violates the separation of powers. So this isn't the correct rule of law. Let's take a moment on this. I'm sorry, everyone. I was totally wrong. The Supreme Court has repeatedly, that makes me feel better at least. The Supreme Court has repeatedly held that Congress should not play any role in the removal of excessive powers, as we said. Therefore, the president may constitutionally remove the director without the consent of the Senate. D is incorrect. This is an overbroad statement of law. So whoever was focused on that NU is a genius. Congress has the power to remove certain types of federal officials, such as those serving as members of the governing bodies of regulatory agencies and inferior officers and agencies where the head of agencies may be removed by the president at will. However, under the separation of powers doctrine, Congress may not play any role in the removal of a presidential appointee. Okay, so it's an overbroad statement of law. They can remove certain types of federal officials, such as lower level officials, but not a presidential appointee. That's who it is, a presidential appointee. So Congress can have no role in the removal of a presidential appointee. I'm actually a lot happier that my gut was wrong and my switch answer was wrong. I was just as wrong as possible. There's no hope for me there. But again, now we'll learn from this question. I think it's tough to see what the rule is, but they were right. Any employee of the executive branch is not true. They can remove lower officers and, inferior officers, but when it comes to top officers, it's absolute under separation of powers theory. All right, good. I was like, if that's the 25th one, I'm so mad. All right, hopefully we have one or two more to redeem ourselves. Congress enacted a statute that made it illegal for any employee without the consent of his or her employer to post on the internet any information concerning the employer. If I learned anything from the last question, I'm very zeroed in on this word any. The purpose of the statute was to prevent employees from revealing their employer's trade secrets. Is the statute constitutional? No, because it's narrowly tailored to further a compelling government interest. No, because it targets a particular medium of communication for special regulation. Yes, because it leaves open ample channels of communication. Yes, because it prevents employees from engaging in unethical conduct. Yo, if we go back to back L's, I'm retiring. All right. Illegal for any employee without the consent of his employer to post on the internet any information concerning the employer. Do we like this? What's the answer here? A. Strong A's, strict scrutiny, content-based. All right, back in the green. See, it's like golf. You can have one shot in the woods and still win the tournament. All right, I think we should be just about finished. Maybe one more. Let's see. Thank you all for bearing with us. A federal statute imposes an excise tax of $100 on each new computer sold in the United States. It also appropriates the entire proceeds of that tax to a special fund, which is required to be used to purchase licenses for computer software that will be made available for use free of charge to any resident of the United States. So an excise tax on $100 on each new computer sold in the United States, and it appropriates the tax to a special fund, which is going to be required to be purchased licenses from the computer software that we made available. Okay. No, because the federal government may not impose any direct taxes on the citizens. No, because the statute takes without just compensation the property of any persons who hold patents or copyrights of computer software. Yes, because a reasonable exercise of government's power to tax and spend for general welfare. Yes, because the patent power authorizes Congress to impose reasonable charges to the sale of technology and to spend the proceeds of those charges to advance the use of technology in the United States. Any answers here? Everyone's going with C. Yeah, we learned one thing today. They're big taxers. Taxing is what we do. I told you, spidey senses were tingling. We'll go to our review. Next February, we'll have another shot at a perfect con law. It's okay, but we'll review which one we got wrong. This question right here, which was that Congress may be involved with the removal of inferior officers. They may not be involved with the removal of presidential appointees. That power is absolute, and it implicates the violation of the separation of powers. Really great job. And I know Grace and a couple others got that question right. So it wasn't your fault. It was all mine. I'll continue to keep working. Any questions about any of the 25 questions we did today at all? No, I think today was a really great class. I hope it reinforced some really important parts of con law. Really, I had fun today. I don't know how, but I had a good time. And everyone, I'll be back at 4 o'clock, same place, doing evidence. And we're doing the questionnaires. Yesterday's questionnaire on Civ Pro was probably the most brutal, teeth pulling experience of my teaching career, because Matt Beckerman is such a genius. And we went over 88 questions on his questionnaire, and I learned a lot. And if I'm learning a lot, there's a lot for you to learn. And everything we talk about is extremely relevant because it's federal law. And just to show everyone real quickly where you can access those videos, if you go to our drive and you go to the crash course.
Sorry, you're not sharing the screen.
Thank you so much, Grace. I know everyone's hungry for lunch. Me too. I just want to show you this one last thing. We'll call it a day. If you go to the complete drive and you go to our course and you go to the MBE course, going through the maze. We do this to keep your brains working. No, I'm just kidding. We're switching to Google Classroom in February. But if you go to videos in the folder, they're questionnaire videos, right? So far, we've done Civ Pro, con law, contracts, real property, torts. These are the videos where we actually go over every question with the questionnaire, with the creator of the questionnaire, Matt Beckerman, except he got his root canal for property. But these 4, Matt and I do them together. They're incredible. And we'll be doing evidence today at 4 o'clock. So you're more than welcome to join. I hope everyone enjoyed today's amazing class, because I really did too.